Okay, Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Khair bin Hasnan. I'm from HM241 2B. According to the situation in question 1A, Dora promised his wife, Mon, to buy her a Ferrari if she allows him to eat 10 dorayaki cakes per day for 1 week. Mon agreed and both of them signed an agreement to this effect. Upon eating 70 dorayaki cakes that week, Dora then refused to buy Mon the Ferrari he promised, saying that Mon does not need it as the tachycopter is much faster than a Ferrari. Mon is very upset and asks for advice. In corresponding to the situation, the issue is about, for this case, is whether Mon can sue his husband Dora because Dora does not perform his promise to buy Mon a Ferrari if she allows him to eat 10 dorayaki cakes per day for 1 week. From the law side, a contract is an agreement that's enforceable by the law as interpreted in Section 2 of the Contracts Act 1950. When an agreement is enforceable by the law, any breach of the promise made in it may lead to legal action. So we look at the case Married versus Married at the year 1970. It shows that how the presumption in domestic agreement was rebooted. The court held the defendant, who is her husband, left matrimonial home. The house was under joint name between the plaintiff and the defendant and subjected to mortgages. The plaintiff and the defendant had discussion. The defendant agreed to pay the wife £40 a month for the purpose of paying the outstanding mortgage payments. But when the payment is completed, the defendant would transfer the property to her. Agreement made in writing, both signed it. After payment completed, the defendant refused to transfer the house. The court held that the parties held the intention of creating legal relations, house to be transferred to the plaintiff, which is her wife, especially when the arrangement was reduced in writing. This is similar in Mon's situation that Dora refused to buy Mon the Ferrari he promised, saying that Mon does not need it as the tachycopter is much more faster than a Ferrari. Okay, then applying the above law and in the situation where Mon agreed and both of them have signed an agreement for Dora to buy Ferrari for Mon, this is if Mon allowed him to eat 10 dorayaki cake per day for entire weeks. After the promise had been fulfilled, Dora then refused to buy the Ferrari. This situation is similar according to Married versus Married, which is the court held there was intention to create legal action. So as a conclusion, based on the above, Mon can take legal action for Dora because he had breached his agreement under Contract Act 1950. That's all from me. Thank you.
Assalamualaikum and a very good evening. So I am Muhammad Zulhimi bin Muazzam from class HM241 2B. So I will tell you guys about how a contract is discharged by frustration. So firstly, the doctrine of frustration applies the contract when it becomes impossible to be performed due to occurrence of some event that radically change the circumstances compacted by parties of contract. This doctrine is defined in the section 5C of Contract Act 1950, although it does not specify use the word of frustration in the provision. Section 57C also said that of the Contract Act 1950 also generally state the sort of occurrence that make a contract become impossible by reason of some event which could not be present, or unlawful. For example, in the case of culture versus power, if party promise to carry a particular act, the law of them to their promise. However, there is one situation where the contract could not be performed or is impossible to be performed. The contract is said to be frustrated because the object is no longer attainable. because of something happened that is outside of the control to the parties. In section 57 of Contract Act talk about a contract discharged by two situations, which are 57 1CA, that contract itself illegal to be performed. The contract discharged by frustration. Secondly, section 57(2), where a contract became impossible to be performed in situation where the subject matter of contract is destroyed. The contract is terminated if the term that the party agree to do something impossible to be performed. It can either at the time the contract was made, when the contract has been made, that the obligation became impossible to perform. The common law has developed precedent of the event that could cause the impossibility of a contract to be performed, such as in the case Taylor versus Caldwell. This case involves that a contract of leasing of music hall for the purpose of a music concert. But before the performance, the music concert was burned to the ground. The issue was whether there was a breach of contract of the owner of the music hall for failing to provide the music hall. It was held that neither party was fault in the case, because the contract was impossible to be performed due to the destruction of the music hall, which was the subject of the contract. The next case is a death or personal incapacity of the contracting party that makes impossibility to perform the contract. In the case Robinson versus Davison, 1870 to 1871, a piano player contracted to be performed in concert hall, but because he fell ill, he could not play the piano on the concert day. The court held that there was personal incapacity of the contracting party that made the contract impossible to be performed. In a conclusion, Section 57(1) of the CA 1950 state that the effect of frustration make contract void. So that's all for me. Thank you.
Assalamualaikum everyone. Today I will present about duties of an agent to his principal. Who is agent and principal? Agent is a person employed to do any act or represent another in dealing with another. Principal is who is so represented. Agent duty is so governed by section 164 to 178 of Contract Act. But today I will only present about 4 sections only. First is section 164 of Contract Act. There is 2 agent duty in section 4. Firstly is to obey principal instruction. Agent must follow the instruction of the principal. If agent does not follow, it is a breach of agency contract. The agent must bear any loss suffered by the principal due to the agent's disobedience. Secondly is to act according to custom where instruction is not given. When the principal does not given any instruction, agent has to act according to normal standard in doing a business. Next section is 165 of Contract Act. Is to exercise care, skill and diligence. Agent must use his skill and exercise diligence for the interest of his principal. Agent must make sure that when he is acting on behalf of the principal, it is important for him to do careful. Next section is section 166 of Contract Act. To render proper account when required by the principal. An agent is bound to render proper account to his principal on demand. The agent must give all account for all monies and properties that he is in charge when the principal acts for it. Next section is 168 of Contract Act, not let his own interest to conflict with his duty. Agent must carry out duty for the interest of his principal. Agent must not allow his interest to go against the interest of his principal. In a decided case, Wong Mun Mai v. Wong Tam Phat and Ano, 1987, Volume 2 of National Law Judiciaries, page 249. The agent, as a defendant, sought the principal's land below market value to his wife. The court gave his decision based on the fact that the agent had the duties to act in a good faith to protect the interests of his principal, and must not do anything that would be conflicting with the interests of the principal. As a conclusion, an agent have many duties to his principal. The breach of the duty can causes many several effects to agent. Every duty is the hard responsibility for an agent must do the duty as well as possible without breach. That's all. Thank you.
Okay, Assalamualaikum warahmatullahi wabarakatuh. And very good evening. Today I would like to present about duty of principal to his principal. Okay, according to section 135 of the Contract Act 1950, is defined as a person employed to do any act for another person or to represent another on dealings with third party. Principal is the person for whom such act is done or who is so represented. There was 5 duties of principal to his agent. First is to pay commission or remuneration to the agent. The principal has to pay the agent his commission or remuneration as agreed in the contract between them. Based on section 173, it states that the agent will lose his right to remuneration if the agent is guilty of misconducting the business of agency. Second is not to willfully prevent or hide the agent from earning his commission. When a principal has appointed a person to be his agent, he cannot employ a second agent to do the same act as the first. He cannot employ a second agent to the same act as the first agent. This is to protect the first agent from not getting the commission that has been promised to him by the principal. Third is to identify and reimburse the agent for act done in the exercise of his duty. Based on section 175 and 176, the principal has the duty to identify the agent for all losses and liability that the agent incurred while perform his duty. For example, the agent already booked and paid the flight ticket, accommodation, and activity. Thus, the principal must pay the agent. Okay. Next is authority of agent. The agent action binds the principal if it is done within the authority given by the principal. Even the agent act outside of the authority given, the act will not bind the principal unless the principal render it later. There are 2 types of authority, which are actual authority and apparent authority or ostensibly authority. Actual authority is expressed to the agent by the principal through an agreement, whether writing or orally. Authority impliedly expected from an agent. Apparent authority is authority given by the law. This authority may arise under two situations. Firstly, based on section 190, where a principal leads a third party to believe that his agent has the authority to make contract for him. This can be done either by words or conduct of the principal. If it is the person who says to a principal without the knowledge or consent of the principal, then it is not apparent authority. Lastly is termination of agency in section 154 to 163. An agency may be terminated in two situations. Firstly is termination by act of the parties. An agency may be terminated by mutual consent of by unliteral revocation by the principal or unliteral derogation by the agent at any time by giving notice. Termination by performance is the contract of agency come to an end when the agent has performed the contract. Termination upon expiry of the period fixed in the contract of agency. Second is termination by operation of law. An agency may be terminated by operation of law in these circumstances. Upon the death of the principal or agent, when the principal or agent become insane, the principal of agent become a bankrupt and by frustration. That's all from me. Thank you.